Okay, we should be recording. Everything's good. This is session 3. Welcome everybody. Outdoor industry law class. I just want to start real quickly by just a couple items regarding the assignments that you all did. Looked like a pretty good job. The one thing that kept coming up over and over on the release agreements was it seemed like there was some reluctance to just recommend that the release contain the words that the participant is releasing the provider from liability for negligence and breach of warranty. I mean, that it doesn't hurt to put that language in there, and that's exactly what you're trying to accomplish with a release, is to release your party from negligent conduct or from a breach of warranty. The other thing that was obvious from the case, and most of you nailed that, which was that the release pretty much covers the inherent risks with the activity, but where you get hung up sometimes is like with this case, some other action, in this case matching the horse with the rider, is not necessarily something that's inherent in the activity of horseback riding. It's more some inherent, or not, I don't know if I want to use the word inherent. It's more of an additional action that the ranch provided, an additional piece of conduct that they were engaged in. So it didn't fit exactly within the inherent risks. That's part of the reason we had the dissent that we had. So anybody have any thoughts, questions on that or anything? I'm going to open up the chat, I think, if I can. Oh, there it is. So go ahead and hit chats if you want. And if I can't see everybody that's here, but be sure to chat to everybody so everybody can see it. And Jessica, are you there? I don't see her.
I'm here. Yep, I'm here.
Oh, hi, Jessica.
Hello.
Would you mind monitoring the chats in case, just to bring them up as the topics are appropriate?
You got it. Yep, you got it.
Okay, thank you. All right.
I had a question.
Yeah.
So for our assignment tonight, like with each question you posed for us to respond to, do you want those to be, like a few sentences or like a few paragraphs or like a page for each?
Just, a few sentences. And just answer it. If the question is, what tort are you likely to run into, describe the tort and why it is you might likely run into it, and whatever the particular question was. And hold up one second. I'm going to go ahead and pull up that course content.
And then I had another question. I was looking around on Blackboard and I noticed for week 1 there was some discussion under the discussion. I wasn't sure if we were supposed to be posting there just because I hadn't seen anything in the syllabus about it.
Okay. Let me see what you're talking about. Hold on just a second. Kind of lost everybody. There we go. So where was that again? It was in the course content for the first week?
It wasn't mentioned anywhere in course content or in the syllabus, but it's over on the side of Blackboard when you see like course content and discussions. And then there was just something in there that said week 1.
Oh, let me go in and look at it.
Yeah, Jeff, I think what she's talking about is we had posted some of the discussion questions for the week, but there's no need for you to actually type responses.
Oh.
Those were prompts for our discussion now during this session for week 1.
Okay, cool.
And so if you see stuff pop up in there, it's more to help you prep for that discussion, not necessarily required that you start typing responses there.
Okay, sweet. Thank you.
Got it. Okay. Yeah, that's discussion for the group session. Good. Let's see. Just finish up on assignments and we'll get moving on today's subject. The risk study, they all look pretty good. Like we said, we got back to you as to whether they were approved or not for your final project. One element that we talked about before last week that we ran through most of them was actually breaking out into a broader risk, looking at risks beyond simply personal injuries and that sort of thing. So if anybody has any specific questions on their particular risk study and then their ultimate final project, why don't you get a hold of Jessica and or I via email, and then we can talk through it. Make sense? Okay. Well, let's start today then. This is like, how many of you sat through those really long, boring videos for the beginning of this session? A few of you, huh? Okay. What I'd like, I'm going to just kind of summarize. I mean, this is ridiculous. We're going to talk about the law and cover it in one chapter and one session. So what I'm going to do, if you don't mind, is I'm going to start rattling off the basic areas of law that we're going to be dealing with in the outdoor industry, and then you guys hit me with some chats. And Jessica, if you see something pop up that is relevant, then let's work our questions that way. Or you can go ahead and just pipe in a question verbally as well. So first area of law we'll be looking at is tort law. And tort law is a civil injury. And what that means is it's a civil action. It's not a criminal action. It's an action where you have a plaintiff and defendant seeking monetary relief. And it's a wrong to a person's property, or economic interest. And we have all types of different kind of torts that we have in today's society. Those torts that we'll be focusing on mainly with the outdoor industry law are, well, first of all, you can start with intentional torts. And those are torts I would suspect you're not going to run into very often. That's where a party, just like it sounds, intends to either to harm another person, either their person, property, or economic interest. And we won't be dealing a lot with that type of intentional tort. Intentional torts are, they intend the consequence of their action, or the actor is substantially certain that the harm is going to occur by virtue of their action. The one intentional tort that might come up, and you guys tell me if this rings true to any of you, is the intentional tort of interfering with a prospective contractual relationship of another. And you have to kind of break down the words, but it's just the way it sounds. It's, for instance, if you as a business or you as a person know that there's a contract between another entity, and you intervene, you actually induce one of those parties to breach the contract by offering the other party a deal or something to breach that contract, then you can be held liable for tortious interference of contract or prospective business relations. You know, I don't know, I can't think of it being overly prevalent in the outdoor industry, but you guys tell me if you run into it. One area that it does pop up quite regularly is when one competitor is taking another competitor's employees, and the competitor who's losing employees complains, "Hey, we were breaching a contract with my employees. You're poaching our employees." Well, unless that employee really has a true employment contract for a specific term, and you're simply an at-will employee, like most of us, be terminated with or without cause, with or without notice, with or without reason, as long as it's not an illegal reason. You know, that's not a very good claim that the party would have for tortious interference, because there really isn't a strong contract anyway. So, okay, I'll move on to probably more prevalent torts, negligence. And all that really is simply that everybody has a duty of care to not put others in unreasonable risk of harm. That's simple enough. And the issues come up with, how do you define what unreasonable risk of harm is? And that's a harm, where a party acts in such a fashion, and that's negligence, to have acted below the standard of care that's acceptable by the law. And the way the law determines whether you've acted in a manner sufficient so as not to put somebody in an unreasonable risk of harm is whether you acted as a reasonably prudent person. In your instance, in our instance, in the outdoor industry, the reasonable prudent person is going to mean you with all of your experience that you have in your field. And so you'll be held to a reasonable standard, reasonable and prudent person with whatever specific knowledge and expertise you have in the outdoor industry, whether it's retail, whether it's guiding, whether it's product development, whatever it is, you're going to be held to that higher standard when you're dealing with third parties. So that's the reasonably prudent person standard. And I did have one person, I think last week, the other type of negligence that we're looking at is negligence per se. Well, first of all, let me back up. With negligence, that one of the defenses is that yes, it can be insured against, and it can be the subject of a release. Let me share a PowerPoint I have here so you're not just looking at me rambling. Hold on. Okay. Hold on, I'm going to share my screen. There you go. Okay. Intentional torts, negligence, kind of just ran through that, reasonably prudent person standard and all that sort of thing, and you'll be held to a higher standard. I jumped past the tort of willful and wanton or reckless and gross negligence. I kind of put all those together, and that's where a party just simply disregards a knowing risk and moves forward with it. In the outdoor industry, maybe that could be if you go ahead and take off in a raft knowing that you don't have a life jacket for somebody, or that you don't have an extra paddle, or something that is just where you recognize the risk and you just disregard it. For willful, wanton, and reckless and gross negligence, that generally can't be insured and generally cannot be the subject of a release, because that would be against public policy. That would promote really bad activities, right, on behalf of people, bad actions. All right, so negligence, we went through that. That's acting below the reasonable standard of care, normally set forth as a reasonably prudent person. The next one is negligence per se, and that is where your conduct violates a statute that protects the party that is injured. So those of you that are, let's use the ski area, the Ski Safety Act, for example. It's negligence per se if the parties if a ski area doesn't post the signs that it's required to post under the Ski Safety Act. The Ski Safety Act sets forth all these duties, and if you don't comply with those duties, then when and it ends up in an injury, the plaintiff doesn't have to prove that that the ski area acted in an unreasonably or wasn't a reasonably prudent ski area. They just have to establish that you did not comply with the statute that set forth what your obligations were. Anybody have any questions on that? In my mind,
I think before you go too much farther with the negligence, we had a really good question about intentional torts.
Okay.
Mark, do you want to chime in and ask your question?
Yeah. So as a ski instructor, especially when you're kind of getting into the more advanced levels, you're going to be exposing students to risk, knowing full and well that there is a high likelihood of them being afraid and using that fear as a tool to help them overcome other aspects of skiing and to help them kind of overcome and build confidence.
Right.
I could see that kind of being a bit of a gray area, or potentially turning bad if, say, the kid ended up having nightmares, or the kid ended up getting injured, or something happened because of it.
Yeah, I can. What do you think, Jessica? You have any thought on that in particular?
I think it has a lot to do with intent. right? So intentional torts, there has to be some sort of malicious intent there. And depending on what that looks like, or whether or not that can be proven, the industry norm, the industry standard, right? That intent likely doesn't exist to actually incite fear. And lacking that, it would be a fairly difficult claim, I think, for somebody to bring that type of intentional tort.
Thank you.
Yeah, I agree with that. The intent for an intentional tort is that your action is substantial. You're substantially sure that your act is going to cause the harm. Well, if you're just simply challenging somebody to be the best skier that they can, that doesn't equate to you substantially believing that conduct's going to result in nightmares or some other injury. So, and again, that's pretty standard in the industry. So I don't think that the way you described it, that would fall into intentional or willful and wanton, reckless, or gross negligence.
Got it. Thank you.
Yep. So anybody have any questions on negligence then? All right, let's move on to negligence. Okay, we talked about negligence per se. Any questions on negligence per se? It's when the way I like to think of it, it establishes what the reasonably prudent person would do. In other words, you have to comply with the statute or you're deemed to have acted negligently. And as per se, as you know what that means, since this is a law class, we have a little Latin, that just means because. You're liable because, and you're liable because the party violated the statute that was intended to protect the person that was injured against the type of harm that was that occurred. And one reason that, and think about the other thing is, oftentimes negligence per se cannot be relieved pursuant to a release, or you have to check insurance policies to see if it covers negligence per se. But one reason you can think of why a release might not cover negligence per se is, for instance, think again of the Ski Safety Act. The Ski Safety Act just sets forth those items that the ski area is obligated to do, and think of the great benefit that the ski area gets. It gets the benefit of being released from liability as long as it does those things. So from a public policy standpoint, it would seem to be difficult to explain or difficult to enforce a statute that releases that much liability and then would also release the ski area from the obligations that it has under that statute, which when you look at it are things that a ski area can readily accomplish. So it makes sense that would be a type of negligence that's pretty easy, fairly easy to prove, as long as you can show that you violated what it was that was intended, or excuse me, what was required under the act, and that particular action caused the injury. All of these relate to that the injury has to be caused by the negligence or negligence per se. Other type of liability that we have in tort is strict liability. And what that means is that just like it sounds, the entity's liable even if they are completely prudent, they haven't acted negligently in any fashion, but the company or the party is still held strictly liable for the injuries associated with the action. And that's associated with abnormally dangerous activities. And don't get that confused with the danger that comes along with climbing or base jumping or skiing. That's not the type of abnormally dangerous activity we're talking about, because we're talking about abnormally dangerous activity that's outside of commonplace as it relates to that industry. So the things you think of where parties are strictly liable is if they're using explosives, if they have wild animals, if they are engaged in some activity that's so abnormally dangerous outside of what is expected in that activity, then you could be held strictly liable. So I don't want you to get confused with like, oh, we're strictly liable because all of our activities are dangerous. Well, no, they are not abnormally dangerous for rock climbing or for skiing or anything of that nature. Does that make sense? So the point is the party would still have to prove that you acted negligently. Okay. All right, let's keep moving on then. A lot of you, almost all the risk plans that we looked at involve some type of property that you operate on, that the business operates on. As an owner or possessor of land, you have liability to those that you have that are on your premises. And when I say land, I'm talking about land or everything permanently affixed to it, buildings and that sort of thing. And the law divides it up into basically 3 different categories. If it's a trespasser on your property, you owe the lowest duty, and that lowest duty is basically not to intentionally harm that trespasser. You know, don't put a tripwire up, blow their legs off. You can't do something to intentionally harm a trespasser. Where we run into it in the outdoor industry is rafting. I don't know how many of you have come upon a piece of private property where the ranchers decided to hang a piece of barbed wire about neck high, right? And in fact, there's a rancher, I want to say it's either on the Dolores or the Animas, I think it was the Dolores, who just kept doing that because in Colorado, us floating through the property is still civil trespass. It's not criminal trespass unless we put our feet down or portage, but it's still civil trespass. So we either have a uneasy truce or you have agreements or leases or whatever that allow our parties to raft through those areas. So generally low duty to the trespasser. It's expanded a little bit. If you know there's people trespassing on a regular basis, you have to act reasonable and perhaps put up a sign that would show them about a condition on the property that might cause them injury that they may not be aware of. Any comments on that one? All right, second type of person on your property is a licensee or a social guest. The book indicated that a licensee, well, in any event, a licensee is a social guest, and that the liability we have for people to come over and watch football or whatever is simply to warn them of conditions that might cause injury that they may not be aware of. Hey, you've got a slick step there. You know, that railing's a little loose, whatever. You don't have to keep your place in a perfectly safe manner for your social guests. So it's a little bit less of a standard. This is the one, the invitee is the one that you'll be dealing with in business, and that's where you invite somebody on your premises to do business. And as such, that's where you have the highest standard of care. You have to take all precautions to protect that invitee from a condition that could pose an unreasonable risk of harm that you are aware of, or, and here's the big one, you should be aware of. So that requires vigilance in terms of inspection and that sort of thing. So you not only do you have to keep your place in a safe, you know, so that it's safe, but also that those items, those conditions that you may not, that you should be aware of. So it requires inspection and also just keeping current on what is, what type of risks you should foresee on your property. Any questions on that one? No? Okay. Let's keep going then. Defenses to torts. We talked about your release. We spend a lot of time on releases. That's what next week's all going to be about, is drafting releases. Assumption of the risk, covenant not to sue. Those are all agreements within your release or exculpatory agreement that you'll use to relieve your operations from liability. In the cases you've read and how much time we've spent on it, you see how critical that your releases are, that they're enforceable. That's what allows you to have a case thrown out on summary judgment as soon as you can establish that the party signed the document. Then you have to go through all the tests about, the tests about whether the release is effective or not. And that's where we spend the time on clear and unequivocal, and that it's easily understandable and those sorts of things. Did anybody have any real problem with the release and exculpatory assignment as it related to at least the case that we looked at? And that, okay. Not hearing any.
I
I'll
do
just
have a question. I mean, kind of related to this. Might be a decent segue. With all the electronic, release forms and stuff that are out there now, are those even? I guess if it's just like swiping your finger, are those equally as valid as a wet ink? Something you can hold up in court and say, "Here it is in black and white."
Yeah, generally those are enforceable. Part of what you'll see is you can't sign it until you've had to have scrolled down and read the whole thing and all of that, and then you sign it. I'll ask you guys, what is the practice at most ski areas? Are they taking electronic signatures, or are they still requiring you to mail in a signed release document? Or in the industries you guys are in?
You can sign a release for your season pass online at Vail Resorts.
Okay.
With REI, we still make participants do written release forms.
I'm trying to think. Monarch requires us to send them in, I believe. I don't. Jessica, do you remember what Crested Butte, is it electronic?
I can't remember for sure. I think I haven't had a pass in like a year, or at least the last 2 seasons.
Mm-hmm.
But I know it was in person for a long time.
Yeah.
Now that Vail has come in, I think that might look a little bit different. Because now the pass is completely different, managed completely differently.
At Alpine, we do both.
Both? Okay. Yeah, there's laws that have acknowledged electronic signatures as being valid. It gets down to, in part, especially if you're looking like some type of release, for instance, where the parties are actually at the location for the activity. There's no reason not to have that signed, because part of what you're going to want to establish if you ever get sued is, hey, our employee was there. This was the discussion we had. We said this wasn't just perfunctory. This thing really means something. You're really giving away your rights. So it's always better if you can, prove that type of discussion and understanding as part of the proof for enforceability. All right, moving on. In terms of some defenses that we have to a claim that's brought by a plaintiff, if the plaintiff was contributorily negligent, and that simply means, and I think it's only enforceable in 3 different states. The last I looked, it was Alabama, Maryland, DC, North Carolina, and Virginia. What that does, this is a really draconian defense. If the plaintiff was the least bit negligent, maybe 1% negligent, then they don't recover anything. What most states are in one of these forms of comparative negligence. In other words, if the jury comes back and finds that your entity is liable, then say for $100,000, and they found that the plaintiff was partially responsible for the action, say 40% negligent, then if you're in a comparative or modified comparative negligence statute, then their recovery would be reduced by 40%, and they'd get $100,000. Most states and Colorado are in the modified comparative negligence, and that simply means that if the plaintiff is 50% as negligent, 50% or more as negligent as the operations, then they recover nothing. The rationale is there, hey, it's just as much your fault as it was our operations, therefore you don't recover anything. So that's one of the defenses that companies have to tort claims. All right, any questions so far? We keep on moving. So we've covered torts. Now we'll get into products liability. And products liability, the first one is, and this applies obviously to those of you that are in retail, those of you that might be leasing products as part of the outdoor activity that you're doing, and renting the product, renting the equipment. And that really is, it's contractual. What does your contract say as it relates to your relationship with your customer? And those are called express warranties. They can be written or oral, and a sample. If I hold up this pen and say, hey, this is what you're getting, then the sample becomes an express warranty. So those are just like they sound. They're expressed, and an express warranty is a promise. Then we have implied warranties that go along with these sale of or lease of goods. And when we talk about goods, we're basically talking about anything that's movable at the time of contracting. The first one's merchantability. That means that it's fit for the ordinary purpose, that it's going to pass without objection in commerce. It does what it's supposed to do. The other related implied warranty, and by implied just means it's there whether you like it or not in the transaction, is fitness for a particular purpose. And this one you guys will, we'll run into in the outdoor industry a lot, because people come to you to ask, hey, is this the proper equipment for me to use to be doing this particular activity? Or you might actually suggest, yeah, this is what you should be using for your particular activity. So in that case, the customer is relying on your expertise about the particular purpose for which the product is intended to be used. And that results in the implied warranty of merchantability. So all of those are a way for a plaintiff to make a claim against a defendant when the product doesn't comply with those warranties, express or implied, and causes a injury or injury to product, injury to person, property, or even an economic issue. Any questions on that, or any chats coming in that we need to address?
About fitness for a particular purpose.
Mm-hmm.
I know when we spoke to James Moss at Outdoor Retailer last year, he talked about helmets in particular, and kind of different certifications and how that works. So because basically he was saying that the certification process for helmets is non-existent or lowly, not particularly regulated. So if you have somebody using a bike helmet for climbing activities, I mean, even if there is no legal definition between the two products, is there an implied, because that's what it's sold for, or is there kind of more definition from the merchandising standpoint?
Yeah, I think if I follow your question on that, first of all, if obviously, if you recommended that they use a bike helmet to mountain climb, that'd be a problem, right? Because wouldn't be fit for that purpose. And then the other would them using a bicycle helmet for climbing, would that be a misuse of the helmet? And that's a defense that you have. And so, unless it's customary within the industry that you use bicycle helmets for climbing, and I don't know, what's your follow-up on that, Al?
I think it's just a matter of the intent. If the product is intended for rock climbing, even without certification or kind of background information, that's what it should be used for. And I could see the law following that same idea, but I could also see the defense of what's the difference between the two, if there's no certification or legal boundaries.
Mm-hmm. Yeah, again, I come back to what's the purpose for which the helmet is intended, and that's that would be what you'd want to be in a position to recommend mountain helmets for people that are mountaineering, and bike helmets for those that are using that are bicycling. One of the questions you brought up is the certification issue. And remember the case in this chapter where the person drowned using the life jacket that was supposedly, what was it, certified for, well, she thought it was certified for the Coast Guard certification or whatever the appropriate certification was, and it turns out that it wasn't. And so if you do indicate that something's certified and it isn't, then that becomes an express warranty, and you can be sued if it doesn't perform according to that certification. So, all right, I'm going to keep moving on.
I had a question about the first case that we studied and the horse. Would that fall within like fitness of particular purpose?
Yes. And I suspect that when, it kept saying that there was a breach of warranty claim, but then didn't talk about it much. My speculation is the breach of warranty claim in that case was that the horse was not fit for the particular purpose, that it wasn't fit for the particular rider. And then what all the defenses would be. Well, the lady said, first of all, the ranch hand warned her that this was a spirited horse, and second of all, she said that that was the horse for her, and she also said that, what else did she say? Oh,
yeah. Along those lines though, like in the sense of like a rock climbing class, like a guided class, if you put like a client on a harder route than they probably are fit for, but maybe like in the situation with the horse, they say, oh, I can do it, but then they wind up getting hurt. Would that fall under fitness for a particular purpose? Because that's the actual rock. It's not an item that's failing. It's the route that's difficult.
Yeah. I believe that would be a claim for negligence and not a breach of warranty, because you're not talking about a movable item that somebody is leasing for a period of time.
Right. Okay.
Yeah. Okay. So those are kind of so you've got products liabilities kind of based on warranty, and here's some of the defenses. You can argue comparative negligence, modified or pure, contributories, like it's so draconian it's not used much. Misuse, the parties using the kind of went into that helmet thing maybe a little bit, using the product for something other than which it's intended, or that the customers altered the product in such a fashion so as to affect it and cause injury. So those would be defenses. As long as you, as part of your operations, didn't say, hey, we can go ahead and use this for that, and or alter a particular piece of equipment then to be used, then obviously you'd be liable if something went wrong. Okay, so there's another way that you're liable for on the product side, and that's what we call strict liability and tort. That's defective product, rendering a product unreasonably dangerous. And keep in mind, chainsaws are dangerous, right? Rum 151's dangerous. I don't know. We got a lot of Ferraris might be dangerous, but they're not unreasonably dangerous. They're not defective. They're just dangerous by virtue of what they are. So when you're talking about this type of strict liability, you're talking about three ways that property can be unreasonably dangerous and impose strict liability on the party for the breach of this strict liability and tort. One, the product is manufactured incorrectly. The metal isn't strong enough. The material that was used doesn't work, or is not the wasn't a proper tensile strength or whatever. Manufacturing defect. The one I think of is the Ducati airbags, right? That are in all the cars that people have, where part of the dashboard's exploding up and hitting them in the face. They say that there's too much explosive material in the airbag, and that's a manufacturing problem, and that's causing part of the dash to blow up. And then there's a design defect, and a design is where it's designed improperly. it's the Ford Pinto case where you had the gas tank in the rear. It was designed that way. It just turns out that made it unreasonably dangerous. And then the third way is failure to warn. When and this is where you see all the warnings on your drugs at the pharmacy, all the warnings showing you not to put your toe under your lawnmower, all that kind of stuff. That's where that is actually a defect in and of itself, a failure to warn. Any thoughts or comments on how that might play out in the outdoor industry? Any of those? Anybody aware of some design or product failures based on either manufacturing design or failure to warn?
A few years ago, Black Diamond, I think, had a big recall on a bunch of their carabiners because the gates weren't closing properly.
Okay. Yep. And
I was
when
also researching that idea on the recall, because that's kind of what I was thinking about. And one of the topics that came up were Backcountry Access's avalanche airbags. They had a trigger malfunction, and then they recalled all their products there. And I'm kind of curious on that actual process, with that strict liability of tort and the recall process associated with it.
Yeah, that's a good one. There's an obligation, obviously, to let your customers know that it's subject to recall. And then the question comes up, and I don't know the answer to this one for sure. I don't know, maybe Jessica does. But if you issue the recall and the customer doesn't elect to pursue the recall, are the persons within the distribution channel still liable? And I don't know the exact answer to that.
I think it depends on certain things, because I had my airbag recalled with Subaru, and they gave you a time limit of like a few years to come in and get it replaced for free. And if you didn't, then they weren't liable anymore.
You would think that makes sense. And one thing I didn't mention when it came to the your liability under strict liability and tort, or these express and implied warranties, if you're a merchant seller and in the business of selling these products, you're liable if you're at any stage of the distribution channel. So if you're the retailer, you're liable for the manufacturing defect. If you're the wholesaler, you're liable for the manufacturing defect. Because part of this was, this is all social policy to hold parties in the distribution chain liable for an injury that results in a defective product. And so you want to make sure that in your terms and conditions with your vendors, that you try to, at least between the two of you, that you push that liability. If you end up getting sued for a manufacturing defect as a retailer, that you have some claim back to get the manufacturer. And also make sure that the manufacturing warranties flow through to the consumer as well. So, but it does go through the entire distribution chain. Let's see. We went through some defenses. Defenses, again, to products liability would be comparative misuse or alteration of the product. Those are some examples of some defenses to a claim. All right, let's get into this one minute. Agency. This has to do with liability of your company for the actions of its agents. And the first thing you have to look at is what authority did and we call it the principal, but I might just say business or operation. What authority did you give that agent? And most of us, you'll see whatever, if you're working for somebody, your authority is expressed in your job description. It'll say what you have the authority to do. Express is just like it sounds, can be oral or written. And implied authority is authority that goes along with your position. It's really close to a parent authority, but if you're the CFO of a company, a public company, it is likely that part of your implied authority would be to enter into contracts with a accounting firm to help you audit your your business, because that's part of your job by virtue of your title. A parent authority is a little bit different. It's what the third party, the customer, appears you have authority to do based on what the business has, how they've held the agent out. Have they given the agent a card? Have they given the agent a title? Have they given the agent a uniform, a car, whatever, so that when somebody deals with you as an agent, then it's reasonable from their perspective to feel that you do have the authority to make an express warranty or be able to bind the company to contractual obligations, that sort of thing. Like if you're working in retail and somebody asks you, hey, does this shrink? And you say, well, nah, it doesn't shrink or whatever. The person that's dealing with you has the right to believe that you have the authority to make that kind of warranty. So it's kind of what is apparent. And when we talk about liability, if you look at contractual liability, it's a really simple rule of thumb. And this is just general, obviously. But if a contract's entered into by an agent for the principal, for the business, within its express, implied, or apparent authority, generally the business is liable because the agent's doing exactly what the business asks them to do, or is acting in a way that is consistent with the apparent or implied authority, so the third party can bring an action against the company or business for that type of contract. Any comments, questions on that? So let's get to this one, and maybe a good way would be to break into rooms here in a minute when we look at this part of the assignment, to look at the outfitter versus guide situation. Is the party an independent contractor or an employee? That raises all kinds of issues. We know that for an employee, the company is vicariously liable for the negligence of that that employee within the course and scope of employment. We also know, and if it's an independent contractor, and this is just a very general statement, generally the party that engaged the independent contractor is not liable for the negligence of the independent contractor in the course and scope of that engagement. So, but keep in mind what I put down here for direct liability, whether it's an independent contractor or an employee, the principal or the company is liable for their own negligence, not simply liable because one of their employees or arguably an independent contractor did something wrong, but the entity itself, the business, is liable if it doesn't do background checks when it should. If and this is where you guys will run into a lot, if the training is inadequate, if there's not proper supervision, the claim, and then there's an injury. Well, the claim would be against the employee that, yeah, the company is vicariously liable because the ski instructor acted in a negligent fashion, but also they could sue the company directly for saying, you didn't have sufficient training. The training wasn't enough. You hired somebody with a bad driving record and they drive your buses to and from. So that's what we call direct liability of the principal. So keeping all those in mind, then I'll just hit damages, and then we'll kind of go into the breaks and maybe look at that guide case. Compensatory damages are just like their sounds. When somebody's injured or property is damaged or economic interest is harmed, there's compensation to make them whole. Lost medical bills, wages, pain and suffering, perhaps, as long as it's not too speculative, lost profits. And it's basically to put the person in a position they would have been had they not been injured, and to pay them for the compensation associated with the injury for which the parties held liable. Special damages are ones that don't seem naturally to occur, but like, for instance, if you breached a contract on delivery and you didn't deliver something as you should, and that caused additional storage, or it caused additional delivery, you had to go to added expense to deliver the product back to the party, then those are what we call special damages. Punitive damages are just like they sound. That's to punish a bad actor. That comes about intentional misconduct, intentional torts, willful and wanton conduct, gross negligence. That's where the jury gets to look at the financial condition of the party that has committed the tort, and gets to say, hey, they actually, part of the trial is around, once they've established liability, is around how much money will it take to punish that business so that they don't act that way again. There are limitations in every state on limitations on damages. As you saw in the Ski Safety Act, damages are limited there. Punitive damages are in some states limited to only compensatory, sometimes twice compensatory damages, or that sort of thing. And that's just all by state statute. So any questions on that? That was a big rattling of the law in 20 minutes. Any good question? Any of these chats we need to address? How about this? Let's break into rooms. Let's see, where do I do that? Right here. I'll break into rooms. Does everybody have the taking sides case that we talked about in terms of the assignment? Let's take about, it's 20 after, let's take about 10 minutes or maybe even less, about 5 minutes, to talk amongst yourselves as to whether you think the guide is an independent contractor or an employee, because it matters as to whether Western is going to be liable for the negligent driving or not, right? Okay, so I'll try to break into rooms here. Manage participants. Let's see. Bear with me, I'm not seeing the breakout rooms. There we go. How many of us are there? Let's see, we've got 19. So let's break into, how about 4 rooms? Is that good? Okay, create some rooms. You guys go back. The question is, come up with whether you think that the guide is an employee of the outfitter or an independent contractor, and why. Okay, all right, I'll hit create rooms. There you go. Open all break rooms. Okay, there you go.
O'clock your time and 5 o'clock my time are different, and 5 o'clock Caitlin's time and my time are like significantly different. So like, I'm assuming it's end of day. But yeah. Oh, he's actually in.
I'm assuming 5 o'clock Mountain Time, but we're hearing different types of discussions of did you do the assignment or.
Yeah. Is the assignment due at the end of the day or 5 o'clock?
5 o'clock Mountain Standard Time, before the I think it's indicated before the session starts.
Oh. Are we able to have them do at the end of the day? Because then we can do the session and like kind of hear input and ask questions.
Yeah, let me talk to Jessica about that. I saw, Sammy, did you send us that comment?
Yeah, a while ago, asking like verification, because I was just saying Caitlin's in Arizona and I'm in New York. So like, is it Mountain Standard Time or is it our time? Like, I wasn't sure.
Yeah, it's Mountain Standard Time. But your question about whether we can have some discussion about the topic before the assignment is a good one. And let's get back to you on that one.
Okay, no problem.
But the assignment that I opened up for next week's due before the class.
Okay. Also, I sent you an email just so you know, during class. So you can check it out after, but we can talk. Okay,
thanks. All right.
So I think the guy, I'll start conversation. I think the guy is a contractor, independent contractor, only because of the fact that he's responsible for using his own equipment. And from my experience, when you're an employee, you're using the company's equipment because they have it based around their guidelines for safety and their regulations, and like so they pre-approve all the equipment that it meets within their liabilities.
That's kind of where I came from. And I was thinking about that same thing regarding the take a side case. So anybody else have any thoughts there?
I think that's really interesting. I hadn't necessarily thought a lot about the apparent, but as soon as he started talking about it, I was like, oh, that makes a lot. That would probably have influenced my assignment, but
Great.
I had actually found the right of control test, which is used by the IRS a lot of times to determine the difference between contractors and employees. So if you can ask the 3 questions, like, you know, do they control in what manner you run the trip and when you run the trip and how you run it, or so like, or what trip you know, what manner. And if you can say no to those, then they're an independent contractor. Whereas I feel like yours is a little different because you're saying, like, you're telling them the manner of how to run the trip. And then
I mean, in a Rent-A-Guide situation, they're just a
broadcast a message to all. If I just close all rooms. Seconds. All right, I guess we're all back, huh? Any general consensus? Somebody want to report from each team, and then we'll just shut her down. I didn't give you probably enough time for this. Anybody?
Our team was split 50-50.
Yeah, right on.
I think it started 50-50 and ended 50-50.
Okay.
We were all around consensus that he is an independent contractor group too.
Okay.
Yeah, we came to the consensus he's an independent contractor. But then when it came to who was liable, whether it was the outfitter and they were responsible for telling their customers that he was an independent contractor or not, we didn't agree on. And we just didn't agree fully on who would be responsible since he was using all his own equipment and vehicle and whatnot. And we kind of decided it came down to like who was insured.
Mm-hmm. And, you know, in terms of actually the whole issue of this exercise, obviously, is if he's a true independent contractor, then Western's not liable for his negligent driving, right? If he's an employee, then Western's liable for his negligent driving. So this was based on a real case and not a lot of guidance, because what happened was it came up, the trial court had indicated that he was I can't remember whether they said he was an independent contractor or an employee. The bottom line is the court sent it back to the trial court and said it's up to the jury to decide whether he's, in other words, it's a question of fact. It's not just law. And so you would weigh everything you guys were just talking about. You know, he uses his own equipment, but can he act without the outfitter? You know, do they control how he does it and all that sort of thing. So ultimately these decisions come down to what a jury says in terms of whether the party is an independent contractor or an employee. So I think you guys probably hit the nail on the head. You looked at apparent authority, express authority, the control, the tools, all that sort of thing. It's not a clear area. So the question is, I would leave you guys to ponder, if you're Western, should you get insurance for that independent contractor to cover his negligence, even if you think he's an independent contractor?
Could you require him to carry insurance to work for you?
Yep. Yes, you could. And make the company a beneficiary, an intended beneficiary under that policy. Yeah.
What effect would that have? Making an intended beneficiary.
If you're an intended, you're called it, well, maybe the right word is an additional insured. If you're an additional insured under his policy, then that means that if you get that, just like it sounds, if there's liability imposed on him, you can collect on his insurance. The thing you'd want to be careful of is if you start insuring somebody, are you making an admission that they're an employee? But you know, you don't want to risk. You really don't want to risk having a jury decide this and then ended up them finding, yeah, he's an employee, and you end up having to pay. So that's really, you know, either requiring him to have insurance or you having insurance, maybe umbrella insurance to cover, because, you know, yeah, somebody have insurance and you're an additional insured, you're supposed to get notice if they ever cancel and all that sort of thing. So you might have a umbrella coverage on top of that to cover in case his insurance lapsed or something. But definitely an issue for you all as you hire or engage either independent contractors or employees. So, all right, any questions, anything? Give me feedback, send me emails on how we can make this particular session better. I hate lecturing to a screen. It's really, there's just so much material to cover in the law that's the best way I thought of handling this one. The stuff is out for session 4, right? And I guess we'll meet again next Wednesday. And feel free to email. It's the best way to contact us, Jessica and I, in the meantime.
I have a couple questions for you really quick.
And we could stay on as long as you want if people have questions. Go ahead.
My first question is in regards to in-class work. You know, I know I can't be the only one with this question, that if we're going to end up missing class, is there anything we need to be doing prior to that to ensure that we're not losing participation points?
Yeah, just basically look at, try and get your assignment in on time, and then go ahead and review I've been doing those videos in advance. So that's one of the participations when I had everybody raise their hand, you know, who looked at them. I didn't hold anybody to anything, but that's one way you participate, is looking at those ahead of time, because especially any of them, but these ones in particular were long and gruesome. So that's, at least from my perspective, probably yours too. But yeah, that's how you participate, is just get your homework in and review and then look at the video afterwards and all that, and have that assignment done. Does that help?
It does. And then my other question for you is in regards to the assignment due time. Is it possible to move that to a midnight timeline either today or on Thursday mornings? Just because I know, because we were talking about this briefly in our breakout session, that we all have different work schedules, and a 5 o'clock turn-in time is a little difficult to meet sometimes.
Okay. Yeah, let me talk to Jessica about it. I think it goes along with the question we had too. Can we have a discussion about the material that makes up the assignment before your assignment's due? That, you know what I mean? Because right now your assignment's due, and then we start talking about it. Part of it is, I don't want to spend the whole class, don't take this wrong, doing your assignment for you. But at the same time, there's a real advantage of struggling through something first and then talking about it. So let me talk to Jessica about that, but we'll see about adjusting. And I guess I would ask other people's input on that. Do you want the time adjusted, or? I don't know.
My only thing about the time being adjusted is I feel like I worry about the quality of my work turned in before this discussion. I actually turned mine in yesterday. I find this incredibly interesting and took a lot of notes when I watched the videos. But at the same time, I do worry about being clear on some of these things. And I don't know, just being able to turn in a higher quality of work and therefore receiving a better mark for it. I could go either way with Kirsten as well. But you know, for me, it's just a matter of I just don't want to get inferior grades because we weren't able to cover the stuff and talk about it before we did the work. But that being said, I understand your argument as well. And to Caressa's point, when we broke out, it does force us to come to class very prepared. So,
Okay.
yeah.
That's okay. All right. I'm getting a lot of yeps agree, and that to have it afterwards, and you kind of hit one nail on the head. It does require everybody to be prepared. If you're
I'll be honest with you, I come more prepared Wednesday night than I do my other classes for that reason. But that being said, I do worry about the quality of the work I'm turning in as well.
Okay. And what I do when I review your work is I'll make comments about, well, what about apparent authority and all that, and maybe you didn't even think about it. I will work hard at not reducing a grade based on something like that. It's really, if I look and see that you're taking it serious, you're doing some, you're really trying to do some creative thinking about it, that goes a long way. So let Jessica and I kind of noodle that a little bit, but let's stick with the time we have for the next assignment, which is that has to do with the statutes affecting your industry. Because I think when I did that one, there really wasn't, if you look at my video, I didn't add a lot to what is in the material and what I'm asking you guys to do in terms of researching what statutes and regulatory authority there might be that's going to impact your industry. So that one I think is less critical that we have the meeting before, frankly, on that one.
I wanted to add in, I really think that what we do in like the economics class and this class with having the breakout sessions and the homework assignments in the class, I think those really help me prepare, but having a flexible date time for when the homework's due, so like Dan was saying, I can really do a clearer job and a better quality job on my homework assignment. Having that later for after the class due date would be a little bit better, but the breakout sessions and the homework in class really are beneficial for sure.
Okay. All right. Well, let me noodle that around too. Okay. Good. Yeah, I know I didn't give you enough time for the breakout session this time because I talked too much. So, all right.
I think if we maybe even just had homework due like an hour after class, because then you have to have the assignment done because you're not going to get it done in that hour, but it will give you the opportunity to just add any like, oh, I didn't even understand that until now I can fix this one question. that would be helpful for me.
That
That's
might
a good
work.
compromise. Yeah, like an hour or two
I
after
agree with
class.
that. I think it gives us a chance to. It forces us to be prepared to come to class like we have been, but it also gives us a chance to review our work right before we turn it in. So I think that's a great idea. Maybe 7 or 8 o'clock to be. To
Yeah.
turn,
I feel like I am
yeah.
emailing just questions, and then if I feel like I could ask them better in these sessions and then just fix my homework versus like emailing you a lot of questions or something that maybe I don't exactly know the point I'm trying to get, like, because I don't understand necessarily the topic or like everything yet. So that might be helpful.
Yeah, that might be a great compromise. Okay. All right. I think that sounds good. Anything else? Feel free to email me, and we'll see you on Wednesday unless somebody has something else.
Thanks for being willing to talk about that.
Oh, you bet. Now I want to make the class better, so you guys keep giving me feedback. Okay. All right.
Thanks.
See ya.
Appreciate
Yeah.
it.
All right.
Thank
Bye.
you so much.
Yep.